So basically, people need to be aware that you don't have to do a rollover, and you might want it. You don't have to do it like now. So if you're a younger surviving spouse, you can take money out of your deceased spouse's IRA account because it's a death benefit. So you can take it out without penalty, even if they weren't 59 and a half yet.
Yes.
Okay. And then when you reach the age that you can take it out yourself, you reach age 59 and a half, you can do a rollover at a later time and still qualify.
Absolutely. There is no limitation on when you can do the rollover.
Yeah.
So, for example, your spouse can die, you can get remarried 3 times and still do a rollover of your previous spouse's IRA. It's good for the rest of your life. You just need to decide when you want to do it.
Yeah.
So there's absolutely no rush to get this done. But unfortunately, oftentimes the other advisors, especially the banks and the call center people, they don't know anything about this.
Yeah.
And so grieving people want to get things done.
Yes.
And we want to wait a little bit and let's make sure we get it done right.
Yeah. So, sort of look before you leap. And unfortunately, in many cases, like you said, people are in grief. They're not really thinking totally clearly, but mostly they're just thinking, well, John's gone. I guess I need to get things settled. And so they just go and try and take care of it themselves. And maybe they need to get some advice before they take these actions. And so quite often when somebody calls me and they say, such and such passed away, basically I say, take care of the funeral. Don't do anything else until you see an attorney and possibly myself, and we can get together and talk about some of these issues.
Absolutely the best advice. You can buy groceries, you can, pay for the funeral expenses, spend some time with your family and grieve, but don't be transferring assets, don't be moving property around until you talk to qualified professionals.
Okay. How does a QTIP trust fit in with these, with the surviving spouse having being a beneficiary for one of these accounts?
Well, this would be one of the ways that you would make sure that the surviving spouse can't do a rollover so that they don't leave it to somebody else, right? So the surviving spouse would still get the income that's being generated. They would get the minimum distributions that are required under the law, but you make sure that they don't leave it to a new spouse or something. It becomes my money, my kids, and you're taking care of them, so you're meeting that obligation that you have, but you're also protecting your kids. So this is very common when that surviving spouse is not the parent of your kids. So a second marriage or so, you may want to make sure you're taking care of them and you use the retirement plan asset to do it. But if they die right away, you also want to make sure that money's coming back to your kids. If you allow the spouse to do a rollover, they can change the beneficiary. And since that's not the parent, that's not going to be your kids anymore.
Yeah. So just to help our viewers out a little bit, because I threw out a term that you and I understand between us, but they may not. So a QTIP means qualified terminable interest property, which you don't probably understand any better than QTIP. But what it means is it's a special kind of trust. Again, as Ray explained, the income has to be currently distributable to the spouse. Actually, it must be distributed each year. And what it means, though, is that this trust will qualify for the unlimited marital deduction for the deceased spouse. And so it is a way, again, that you can leave these retirement accounts. If they're the beneficiary, it's going to qualify as well, if the surviving spouse is beneficiary. But again, if you want to control where the property is going to ultimately go after the death of the surviving spouse, then you want to consider using one of these trusts. And so QTIP is a good shorthand thing to write down and talk to, again, your advisor about how does it fit in. Okay. What considerations apply for the children or other beneficiaries of a person making an estate plan?
Well, if you have minor children, right? Children under the age of 18. In fact, very few people actually want to leave an 18-year-old all of their wealth, right? You create a trust so that the child develops a little maturity before you give them the ability to manage all this wealth.
Yes.
And yet, when your retirement plan, you just name the child outright, you're creating a plan that is destined to fail, because the child is going to have access to all of that IRA money at age 18. Mm-hmm. Now, they may also need a guardianship until 18 because that money's not in the trust, so someone has to supervise it. But then when they turn 18, they're going to take that money out of the IRA. Is your 18-year-old going to remember that they have to pay income tax? Or are they going to buy a whole bunch of stuff and then 3 years later get a letter from the IRS saying, what happened to the income tax you were supposed to pay on this? Uh-huh. And kids don't oftentimes understand, what the tax implications are for doing things, right? That's a trustee will help them learn and develop maturity. So we want to have a plan that's coordinated between the retirement plan assets and the rest of the assets. So we want to leave that money in trust for the kids, just like you're doing with the rest of the assets. But there are special rules that apply for how that trust has to be drafted, how that has to be written, and what the standards are for administering it. Mm-hmm. Be very careful. I still see on blogs now that attorneys are writing, never leave your retirement plan assets to a trust. Mm-hmm. And that's just not true. Mm-hmm. I mean, these rules were created in 2001 specifically so that people could leave the money in trust, but they have to have special language in the trust to make sure that their trust complies with these rules.
Right. So maybe we could talk a little bit about what the trust has to do, how it has to be set up.
Absolutely. It's called a conduit trust, is the general way that we do it. And it's just designed to say, if any money comes out of the retirement plan, it has to go right to the beneficiary. Mm-hmm. So you're not accumulating anything in the trust.
Yes.
The big difference here, though, is instead of the beneficiary deciding what comes out, it's now the trustee that makes that decision. Mm-hmm. The trustee, of course, will also make sure that taxes are paid. But now if your child needs to pay a bill, pay for school, the trustee decides, well, where's the best place to take this money, rather than the beneficiary just kind of deciding, well, I want a new car, I'll take it from my IRA. Mm-hmm. And then their taxes and all the other issues that go along with that.
Yeah. So I think what the point related to this, though, is that when you have a typical living trust, it's usually set up for a lot of different beneficiaries. With this conduit trust, what's important is basically you're going to have a trust more or less set up for that account.
Yes.
So, and it's just for that one beneficiary. And you can also divide an account after death. So you could set up, you've got 3 children, you can set up a conduit trust for each one and divide the trust for each of them. The other thing is, again, that you're putting an 18-year-old child, maybe younger, in a position, well, it's not younger because there will be a guardian again if they're younger, but 18, they have to make investment decisions. How is this IRA going to be invested? And so, they just don't have the maturity yet in most cases. You may have a savant child that's a great investor, but for most of them they don't. And so they need the experience and advice to get to the place where they can manage the account on their own. Okay, let's see here. Maybe we only have a couple minutes left.
Let me give you one more benefit of the conduit trust, just briefly, and that is, if the IRS, when you create your beneficiary designations, also looks to see who contingent beneficiaries are.
Yes.
So, for example, I have a daughter, Natalie, and I want to leave my retirement plan to her. But if she dies, I'm going to leave it to my sister. Remember, my sister is older than Natalie, so if all I've done is said first to Natalie, then to my sister becomes the measuring life for Natalie's distributions.
Ah, yes.
If we're using a conduit trust, we don't look at the contingent beneficiaries, we only look at the actual beneficiary, which would be Natalie. So I can create contingent beneficiaries that can be very different than the primary beneficiary. But if you just write names down on the form, you're always looking at, okay, who did you name and what's the oldest possible beneficiary to determine what the measuring life is for your child.
Yeah. Although there is the other thing that when a person passes away, if they've named a beneficiary and that person is living and they have contingent beneficiaries, as I understand it, basically the contingent beneficiaries sort of go away.
They can go away.
Yeah.
And you know, the IRS is still changing the rules on this on a regular basis.
Okay.
So we still get 10 rulings a month in this area. And
Okay.
you know, and the rules are over 10 years old.
Yes.
So there's still a lot to be fleshed out. But you want to make sure you get qualified professional advice in this area. Even if you have adult children, is this really the best way to leave them the money?
Right.
You know, outright versus in the trust, because there may be some big benefits to having it in trust for adult children as well.
Okay. Well, we're really about out of time, so I guess what I'd like you to do is maybe just throw out a final thought for people related to this, and then we'll wrap this thing up.
So, you know, well, you want to make sure that you're working with a qualified attorney who understands retirement plans and estate plan. The retirement plan is this first or second largest asset in the estate. It makes a huge difference to the overall wealth creation of the family itself. And do not just try and say Quicken Will Writer or you know, some Susie Orman or LegalZoom. They're not going to give you advice in this area. And this is where we're seeing tremendous problems, is people not following the rules and then no more stretch out, take everything out right away or within 5 years.
Yeah. Okay. Ray, thank you so much for being my guest.
Hey, thanks, Mike.
Folks, I hope that you found this thought-provoking, and also say, okay, now I need to get some help. And so that's what it's all about here, is to share some information to make you aware of an issue that you may need to seek help for. And so this is a big one. Anyway, we'll see you next time on Financial Insider Weekly.